Hi, this is Joseph Del Grande, and this will be part 2 of how I was unlawfully stripped of what's called a supplemental 207A2 benefit by the Greenville Fire District by engaging in multiple false claims to the court, well under the oath of the penalty of perjury. And as I said, in the first part, this is my opinion. Everything I'm stating here is my opinion. However, my opinion is supported by overwhelming, extensively examined evidence and the Supreme Court decision, which clearly cites the lack of credibility by the district awarding me the benefit in the first place. It says, the law is well settled. This is the Supreme Court judge who awarded me the benefit. The law is well settled that a hearing officer's findings are entitled to considerable weight, whereas here questions of credibility are involved. She's referring to the lack of credibility of the district's argument in its entirety. Not just Dr. Silverman's fraudulent claims, but the entire argument that the Greenville Fire District put forth. And then she goes on to say on the next page, Greenville's entire argument at this level in front of the appellate court is irrelevant because they are arguing a 207A1 to 207A2 determinations, not a 207A1 determination. They approved my 207A1 benefit. They were appealing a 207A2 award by the arbitrator and a 207A2 opinion and decision, not an opinion and decision, a decision in order by the Supreme Court judge. And she goes on to say that this court finds that the consideration of the additional issue that had been beyond the legal scope of the respondent's authority. Indeed, case law holds that the retirements set forth in General Enlistment Law 207A1 are not applicable with respect to General Enlistment Law 207A2. See the matter of McGowan versus Fairview Fire District. And this court finds that this necessarily includes General Enlistment Law 207A1's requirement that a continuation of salary and medical benefits are contingent upon the firefighter's non-refusal of medical treatment. Had the legislature intended to impose such a requirement on 207A2 benefits, it easily could have provided for the same. So the court is clearly saying here, the Supreme Court is the subject matter jurisdiction, the subject matter that the district was appealing to the appellate court was not the subject matter that the appellate court reviewed. They reviewed this matter as if they were appealing a 207A1 determination. They approved the 207A1, my 207A1 benefit. They were appealing two 207A2 benefits. So their entire argument is not even relevant to the subject matter that was before the appellate court. Okay, so moving forward, let's see, and this is where the Supreme Court judge ruled that the district's argument was arbitrary and capricious and without rationale, and an abuse of discretion under CPLR 7803 because of the lack of credibility and the lack of relevance and the lack of any reasonability in their claims based on the evidence in the record. And it's 100% in line with the arbitrator's decision. Okay? The arbitrator's decision says the same thing. The district's claims have no credibility. And again, going back to the district's, I'm going to refer to a letter that the district sent to the Scarsdale Inquirer. This is clearly an arbitration. Okay? In any reasonable person's mind that reads this document It says in the matter of the arbitration of, at the bottom it says Howard C. Edelman, arbitrator. Under the law, again, it says right there, and I was appointed arbitrator under the procedure set forth by the Greenville Fire District. There's something in the law that's caused within a reasonable person's mind, a rational, reasonable person's mind, in deducting and figuring out claims in a case in the record if they're not supported by the record on a whole, on all the other credible evidence. They're dismissed and given no weight because they don't make any sense and they could not possibly be true. This is the arbitrator's decision. Clearly it says award. Claimant, Firefighter Del Grand, and Howard C. Edelman signed under oath as Howard C. Edelman. Okay, there's no ambiguity, there's no question. There's no question what he was doing here. There's no question what his decision was. It's clear as day and night. So for the district to go on in their article, which they felt compelled to write to the Scarsdale Inquirer editor, and say that the hearing officer, Edelman, mistakenly billed me for one half of the hearing costs. However, the district immediately alerted the hearing officer to his errors. I don't know if you can see that right there in the middle. That's a lie. This is a bill. Everything here is about the credibility, lack of credibility by the district's argument. Here's a bill I received almost a year before Edelman rendered his decision as an arbitration, which I just showed you on the other page, October 20th, 2010. His decision was in October 2011, which shows I was being billed half and the fire district was being billed half. They received this bill. They saw that I was being billed half. Okay, payable by the district, payable by Del Grand. Okay, so when they're saying they immediately took action and notified Edelman that he wasn't following their hearing procedure, this was a year before his decision. Immediately is a year and a half later notifying him? That's a blatant, outright lie. And that's what the district did throughout this whole procedure, this whole proceeding. It's one lie on top of another lie on top of irrelevant, irrational claims. Okay, let's see what else it says on here. It's saying that the courts conclusively have ruled the board's decision to deny Del Grand enhanced benefits was sound, lawful, and proper in all respects. Indeed, the final court to consider this matter specifically ruled the board was entitled to deny Del Grand enhanced benefits because the board's determination was supported by substantial evidence. That's a joke. That's arbitrary, capricious, and without rationale. You don't go from having no credibility to saying that something is supported by substantial evidence. Substantial evidence under the law is in a rational, reasonable person's mind to support an ultimate fact or facts. The rationality part of it. There's nothing in the fire district's argument that supports any fact or facts. It's one lie on top of another lie. Okay, let's see what else they say in their letter. Oh, however, the board is tasked with the public trust responsibility to oversee the GFD and provide excellent fire and emergency service in fiscally prudent manner. That's a lie. Okay, here I have a bill I don't know if you can see it there. Let's see if I get it right. They paid this unqualified doctor to falsify medical evidence. Let's see, $4,350. They paid Dr. Silverman, okay, for his testimony, which he did nothing but give biased opinion and ultimately falsified, tampered with, and fabricated medical evidence in order for the court to rule in their favor, to deceive the court. Okay, let's see what else they got on here. And besides that, every Silverman himself, every one of his reports states at the bottom, I warn Silverman MD, being a physician duly licensed to practice the state of New York, pursuant to GML 207a, hereby affirm to you under the penalty of perjury that the statements contained herein are true and accurate. Okay, that's Dr. Silverman's affirming under the penalty of perjury. He committed perjury on this document, and then he affirmed under the penalty of perjury that he didn't. Okay, let's see, where else are we at here? And also, I have, getting back to the amount that they paid Silverman just for his testimony. This doesn't include his 2 exams that he had of me, that he conducted of me. They paid him $4,350 just for his testimony, which is an extraordinary amount of money for testimony from a doctor for a couple of hours. They paid him, from what I was told, around $6,000 for each exam that he performed on me, where he had his hands on me and examined me. And during these exams, he found me to be permanently disabled. Okay? And they were 2.5 years apart. And both of them, he said, I was, the second one, 2.5 years later, said I was just as disabled as I was in the first one 2.5 years prior. Okay, let's get back to their article, back to the Scarsdale Inquirer. Was sound and lawful and profitable in all respects. Indeed, the final court to consider this matter, blah, blah, blah. I'm getting back to the public trust and with the Greenville Fire District being responsible for not squandering money. They spent over $140,000 on this corrupt attorney, Conroe, and this corrupt Dr. Silverman, in order to lie and cheat, falsify, fabricate, lie about evidence, say evidence is in the record that's not in the record, take evidence out, tamper with evidence in the record, take a doctor's report that's in the record, take it out of the record, just in the rare case that the court would ever fact check and see if that doctor's report is in there. This is the kind of honesty and integrity and moral fabric that the Greenville Fire District is working with to go out of their way to squander $140,000 on a corrupt attorney and a corrupt doctor who says he's not qualified repeatedly, falsified medical evidence. The attorney tampered with medical evidence, took medical evidence out of the record, all to deceive the court, when they could have just came to me and said, you know what, make me an offer. You know, I would have taken $200,000 to avoid all of this nonsense. Even though the case is worth probably like $400 and something thousand, they really owe me if they followed the law and paid me the benefit. You know, based on the approval of the performance of duty under Social Security Law 363C, as they did in the Mazzullo and the McGowan case. But they decided to just lie and cheat and lie and cheat and just keep going and going and going until they got to a point where I'll explain later how it turned into arbitrary and capricious and without rationale from the Supreme Court to support it by substantial evidence by the appellate. The appellate never even reviewed the case, and I will give the motive as to why I have indisputable, fact-checked evidence as to why they reversed the Supreme Court decision. Okay, let's get back to their letter again. They're saying Mr. Edelman is a non-GFD employee. Mr. Edelman was the arbitrator who would make a non-binding recommendation. That's a lie. As I showed you the documents repeatedly, he made a finally binding arbitration award, and he was handpicked by the fire district. There was no joint. Didn't have the union. I didn't have my attorney get together and say, okay, we're picking Edelman. The fire district picked Edelman. And Edelman is a member of the American Arbitration Association, as I said in part one. And in part one, as being part of the American Arbitration Association, there's rules and regulations you're supposed to follow. Okay? He's supposed to follow the CBA, the collective bargaining agreement that I was covered under when I first got injured. That's supposed to control the way he conducts, and that actually is the way he conducted his written document, his written in accordance with the CBA. Okay, but for some strange reason, even though he states he's a member of the American Arbitration Association, his decision is not in a list. When I called the American Arbitration Association, I said, yes, he is a member, but my decision is not listed with the American Arbitration Association for some odd reason. So he's portraying himself to be a member of the American Arbitration Association, which he should have followed the rules. He's implying that he's following the rules of the American Arbitration Association, but he never filed a case with the American Arbitration Association. Okay, I know I'm skipping around a little bit here, but you got a feel if you saw part one. Let's see, what else did they say in this letter? The hearing officer overlooked key medical elements. According to the board, exercised its right and responsibility to reject the hearing officer's recommendation, denied Del Grande enhanced benefits. That's a lie. Edelman didn't overlook anything. He did a thorough job. The only thing he did wrong was yield to the fire district's double-played procedure where they were waiting to see what his decision was, like I said in part one. When they found that he ruled against them, they didn't say a peep. It says here they immediately notified the arbitrator that he was wrong and he didn't follow the hearing procedure. He made a decision in October. They didn't say a peep to anybody until February, 4 months later. And they got this bill a year and a half prior. They didn't say a peep when they got the bill, that they knew he wasn't following their procedure because they were double playing it. It's like I said in the first part. If he had ruled in favor of the district would have argued, no, he's an arbitrator. Look, this says matter of the American arbitrator, matter of the arbitration of Joseph Del Grande. How could you argue that he's not an arbitrator? No rational, reasonable person's mind could argue that he's not an arbitrator. But they lost, so that's what they did. Let's see what else we got. Oh, the fact that the board conducted itself properly, procedurally, and substantially is easily known and knowable. The court decision fully and finally affirming the board's determination is publicly available. That's a corrupt joke, which is a complete lie. They did not conduct themselves properly and procedurally. They lied and cheated and lied. They committed perjury and fraud under the penalty of perjury. Here's Mary Lou Comroe, an attorney admitted to practice law in the courts of New York State, hereby affirms that the penalty of perjury the following to be true. That's her affirming under the penalty of perjury the following to be true. And what does she do? She points to a page here in the record. Del Grande, however, did not turn over his medical. That's a lie. That was already proven. I gave him 3 signed medical release documents that gave him access to all my medical records. One lie on top of another. They established one lie in order to establish a second lie, to facilitate a second lie. Dr. Silverman's addendum demonstrates that those records were pertinent because the records show that Del Grande's herniation resolved. They should point to a page number, 1092, 1095 in the record. Okay? That's a lie. This is the report right here. This is page 1092. This is where he falsifies medical evidence. If you could see it right there, he puts the top part of my doctor's report, who was primarily examining my neck, as Edelman clearly stated in the arbitration, which said I had full strength of my arms and legs, and this, I had full strength of my arms and legs the whole time through this whole injury. My injury was in my lower back. These morons. Every other doctor that examined me always said I had full strength in my arms and my legs. That shows the corrupt, deceptive nature of Dr. Silverman's motives. Then he only put 1 or 2 sentences in there, and then right here, he puts these fraudulent statements in saying I'd be able to do a whole bunch of activities and blah, blah, blah. That's not in the doctor's report. He took words out of the doctor's report that said the actual doctor's report that he's trying to falsify. The doctor's report says, impressions, the patient's been followed for a back pain and a work-related injury. He does have some neck pain as well. There's a bit of numbness in his right thigh occasionally. Mildly decreased cervical and lumbar range. Impressions, neck and low back pain, chronic. Activity modifications and precautions were discussed. I formally request authorization for cervical physical therapy. I do not feel this patient is a candidate for spinal surgery. Follow up again with myself as needed. He is told to call for any problems. This is what the doctor's report actually says that he falsified. Impressions, neck and low back pain, chronic. It doesn't say anything about me being able to do a whole range of activities. Silverman falsified it and put his wording in place of all of the other words that are reported that I just showed you. And the best part about it is it contradicts Silverman's own report. Silverman's own exam of me, when he had his hands on me and examined me, was only a few weeks prior to the date of this report. The date of this report is 12/15/08. It says 12/15/08. He's referring to Dr. Perkins' report. The report that he falsified and fabricated. This is his report, okay? See the date? 11/24/08. 11/24/08. Here's what he says. I think the anatomy at this point has not changed. Based on the information that we have, he still appears to have limitations based on the herniation at L3 and L4, which was related to the incident of 12/7/05. Okay, so he's saying I'm still permanently disabled almost 3 years after my injury. Regardless of the information contained in the medical record, this is clearly a surgical collectible lesion, and with appropriate surgical consultation would not require a major intervention to do so. I think excuse me. I think correction at the L3, L4 is clearly related to the 12/7/05 incident. This is Dr. Silverman's report, okay? This is the last medical evidence, if you want to call his report medical evidence, which apparently the district has the right to, then he's disqualifying himself. Because he's either saying he's not qualified to evaluate a firefighter based on his hands-on exam, because he's saying I'm still permanently disabled. Then a few weeks later, he makes an addendum and says I magically, my injury resolved itself. That's not physically or physiologically or rationally possible. This is how corrupt this whole case is based, solely focusing on this evidence right here. Falsifying medical evidence against his own findings. He found me to be permanently disabled. I don't even need to go out and show all the other workers' comp doctors who found me to be permanently disabled. He found me to be permanently disabled. But when that didn't work, Conroe goes out to Edelman, to Silverman, and says, Silverman, we got to put in an addendum, and I want you to falsify and fabricate and attach, use the first sentence of Delgran's doctor's report, and then strip the rest of the report out and put your own words in there so you can deceive the court. This is Silverman's words, making it appear that it was spoken by my own doctor. The examination doesn't sound very dramatic, and he appears to be quite functional. Symptomatically, he was reporting a little bit of numbness to the right eye occasionally, but some numbness and some numbness of the hand, but otherwise denying any pain, numbness, tingling, or any weakness in the arms and legs. Functionally, he sounds pretty good. He sounds like he'd be able to do a wide range of activities. How does this moron go from saying I'm permanently disabled in his report a few weeks prior to saying this without any medical evidence at all? Falsifying, tampering with medical evidence, stripping medical evidence out of the record to deceive the court. And as I said before, this is what he said at the bottom. Him and Conroe. What does it say? I warned Silverman, MD, being a physician duly licensed to practice the state of New York, pursuant to CPRL 2016, hereby affirm to you under the penalty of perjury that the statements contained herein are true and accurate. Okay? That's perjury. When you make a claim like that in a legal proceeding and you know it's not true, those are the two main criteria to making it perjury. Okay? Perjury is the intentional act of swearing a false oath or falsifying an affirmation to tell the truth, whether spoken or in writing, concerning matters material to an official proceeding. Criminality culpability only attaches at the instant the declarant falsely asserts the truth of the statements made or to be made which are material to the outcome of the proceeding. Okay, that's the first criteria which the district and Silverman repeatedly met under the penalty of perjury. The second criteria is that they knew when they were making these claims in a legal proceeding, they knew that they weren't true. They knew that they were making false claims to deceive the court, to rule in their favor. They met the criteria repeatedly. And the other thing that's another joke is, excuse me, in the addendum, when Conroe tells Silverman to write this addendum, see how many months, April, so he examined me in December, January, February, March, 4 or 5 months later. And the addendum, at the beginning of the addendum, he never mentions that he examined me. Firefighter Douglas was previously seen and evaluated for an independent medical evaluation on 5/16/06. That's a lie. He just examined me in November of 08, which was only, like I said, 4 or 5 months prior. Because he's trying to deceive the court into making it seem like he never examined me between his first exam in 06. He just wanted to completely hide his exam of me where he found me to be permanently disabled. And the other interesting thing is they're saying I didn't provide medical records. He says at the beginning of every report, he names all the medical records that I provided. In his exam of me in 06, his exam of me in 08, and his exam of me in the addendum in 09. And how all of a sudden, if I didn't give them the medical records, how did they magically have access to the medical records in the addendum? Conroe saying in her brief that they had to file an addendum to get the medical records. How is them filing an addendum giving the medical records that I supposedly never gave them? That's a ridiculous proposition. That's a joke. That's corrupt. Perjury and fraud on top of perjury and fraud. That's like I say, how would a fire district had a firefighter? I was employed there for over 20 years. Sorry, I got something in my throat. I received multiple merit awards during my career. I never had a problem. One of my merit awards was even for my response on 9/11. Okay? So how could they not give me this supplemental benefit was simply a temporary benefit. It's only till I'm age 62, which was only for maybe 15 years. It's not a lifelong benefit that would bankrupt the district. Plus, I had people investigate. They had plenty of money to give me without having any kind of consequence on the public fisc. That's a joke. Also, I'd like to add, anybody who has any input, comments, contact me at 4joe39@yahoo.com. And I will send you any of these legal documents. I have the entire record on appeal here. I have every document that there is. There's 2 of the books there. There's another book over here. All right? Again, 4joe39@yahoo.com. The district has to be held responsible, held accountable, and make me whole and pay me this benefit. Thank you.